Okay, Attorney Steve, we are in part 2 of our Jesinoski United States Supreme Court case analysis, and we were talking about rescission and what happens when you rescind. So when you rescind, you send in your written notice of rescission. The lender or creditor has 20 days to basically, if they want to challenge that, is to go into court and seek declaratory relief and basically prove that there is no valid right to rescind under federal truth in lending law. 20 days. What happens, should happen, I should say, because I'm sure there's going to be a lot of litigation on this point, is that the borrower, the lender, should then tender back the payments, the loan payments, funds and fees received in connection with the loan, and refund those back. Now, the security interest on your property is void as a matter of law. That's in the statute. And so theoretically there should be no foreclosures. This is why I think we're going to see a lot of litigation when you have lenders sending in these, borrowers sending in these notices saying, I have a right to rescind, I have material loan violations. There's going to be a big fight because you, as a lender, as a creditor, lender, you don't want to just concede if there's no actual material violation. So these are things that are going to have to be very closely looked at. For lenders, you're going to have to be very careful when you're originating loans to make sure you're making all those material disclosures that you need. I can tell you from past experience, it's been a circus in the kinds of things we've seen in forensic loan audits and those kinds of things, material violations over and over and over again, especially in option arm and negative amortization loans. So you got to be very careful as a lender to make sure these disclosures are clear. So that's basically the process of rescission. That's what's supposed to happen. Some other issues that came up in the case. So let's hit our key points here real quick. Again, written notice sufficient. No need to explain your grounds in your rescission letter. Sometimes we'll have people say, do I have to lay forth my entire forensic loan analysis and lay out everything, all my grounds? The statute doesn't say that you need to set forth in detail each grounds that you have for material violation. Okay, so that's something you need to discuss with real estate counsel, decide exactly what you want to do. So no need to explain. Creditor needs to act. Again, this is the key point. In the past, creditors, banks, lenders would sit around and do nothing. Oftentimes they would not respond to a rescission letter and just say, hey, I'll see you, if you want to file a lawsuit, I'll deal with you in court. Oh, you don't have the money, okay, I'm not going to worry about it. This could create problems. Not responding can now create some problems for you with this new holding. So you need to act, think about filing declaratory relief if you're a servicer, if you're a bank, fighting on these kinds of claims. One of the other big key questions that comes up is tender, and this comes up, has been around forever in real estate and foreclosure litigation. Do I have to tender? Do I have to tender the loan balance? And what we've always called the sack of cash theory. So you have to bring a whole sack of cash in to, if you want to rescind your loan, you have to bring in the whole sack of cash. You'll $611,000, then subtract what the bank owes you. Maybe it's $100,000. You owe me $100,000. I owe you $611, so let's call it $511. So that used to be sort of the prevailing theory amongst many of the banks, is that's how it worked. Oh, you can't bring in the $511. Oh, you can't tender. You've got no claim. So that used to be sort of the prevailing attitude. Well, in the Jesinoski case, the court discussed it and said this common law notion of how rescission normally works that way, you give me back, I give you back, is not the rule when it comes to TILA rescission cases. So you have to bear that in mind. The old bring me the sack of cash theory, probably not going to save you if you're a bank creditor, so forth and so on. Again, discovery, equitable tolling. I know people are going to ask, can I come back and bring my claim from 2007, 2006? Equitable tolling, that's going to be a question to be looked at further. It's a question we have to investigate further, do more legal research on. My gut feeling is it's still going to be a very difficult claim to try to bring, and unless you can find some case law, we'll do some research on that to see where that is. But discovery rule, equitable tolling, that's something that needs to be looked into further. Other things is unjust enrichment. You know, what would happen in the case if a borrower went through this process, and let's change the dates from 2007. Let's say this was a 2009 loan at the consummation stage, and let's say 2009, and now the refusal, let's say you mailed this 2012, and then the refusal was here in 2013, and now your house was foreclosed on even though your security instrument was supposed to be void, right? Let's say the bank didn't respond, which would be the typical response you would see, and the security instrument was void. Your funds were never returned to you upon a rescission. Let's assume that your rescission was proper, that you do have adequate material violations. Then what happens? As we discussed in our example, say you were owed $100,000 and the bank foreclosed, got its money back, but you never got your $100,000 back. So one claim that may come up, we may see more of these claims, is a claim for unjust enrichment, which we talk about over here on our key points board. And unjust enrichment, it may be a theory to be explored. I'm not saying it's a winner, I'm saying it's a theory to be explored. The bank was theoretically unjustly enriched by getting their money back and not having to pay you back on your funds. If you're within the applicable time frames here, which arguably is 3 or 4 years, it depends how you bring your claim. If it's a claim based on contract, arising out of a contract, it's a 4-year statute of limitations in California. If it's a claim arising out of liability created by a statute, it's 3 years. So, you know, it depends how you look at your claim and how you bring these up. And I haven't done any research in this area, so it's, again, another issue that's ripe for investigation. So this is a basic overview of federal truth in lending law. Jesinoski stood for the proposition that mailing in a written notice of rescission is sufficient, that you do not need to file a lawsuit within 3 years, but you do need to send what I would recommend certified mail with tracking. You do need to send in a written notification of your right to rescind within 3 years. The Aquin versus Beach case is still apparently controlling precedent, and so it's a 3-year window. Anyway, this is Attorney Steve Vondran, and if you have questions about federal truth in lending law, Reg Z, if you need more information, visit our website at TILAlawyers.com. That's TILA lawyers.com, TILAlawyers.com, and make sure you subscribe, because we're going to have some more great videos coming out about truth in lending law, real estate litigation, general litigation tips to help you. So thanks so much for listening. We appreciate you watching us and following us. Feel free to share our video on your social media networks, and we'll see you again. Take care now.